Judge, thank you so much for that incredibly kind introduction. Thank you for the warm welcome. It's truly an honor and a privilege to be here to deliver the Quackenbush Lecture. Judge Quackenbush is nationally renowned as a jurist, so it's a great personal pleasure to get to deliver a lecture that is named after him. In 1928, the Supreme Court considered Olmstead versus the United States, and the issue was whether wiretapping is a search within the meaning of the Fourth Amendment. The wiretap was placed on the phone outside the home. It was attached to the wire that brought the phone into the home. And the United States Supreme Court said that therefore, since there wasn't a physical trespass, it wasn't a search within the meaning of the Fourth Amendment. This is the case where Justice Brandeis wrote a very famous dissent, where among other things he said, "The right to be let alone is one of the most fundamental rights that we all possess." It's quite stunning to think that the holding in Olmstead was the governing law of the Fourth Amendment for almost 40 years. It wasn't until 1967, in Katz versus United States, that the Supreme Court took a different approach with regard to the Fourth Amendment. Katz involved somebody who was making a phone call from a telephone booth. The government tapped that phone. And the question is, should that be regarded as a search regarding the Fourth Amendment? And the Supreme Court found that it was a search. And the Supreme Court said, no longer does there have to be a physical trespass in order to trigger the Fourth Amendment. The key is there a reasonable expectation of privacy? We are now 45 years since Katz. The methods of communication have changed so dramatically. The ways in which people can communicate to one another have increased so dramatically. The ways in which the government can eavesdrop and intercept those communications have also radically increased. And I think the question that we have to face, and there's one that touches all of us, is, can the Supreme Court deal with the technology of the 21st century? Can a Fourth Amendment that was adopted in 1791 really be adapted to the technology of the 21st century? I want to make 3 points this afternoon in trying to assess this question. First, I want to argue to you that the recent Supreme Court cases about this bode poorly in trying to predict whether the Supreme Court can deal effectively with technology in the Fourth Amendment. Second, I want to argue to you that the conceptual frameworks that have been developed so far are not going to be effective in dealing with the privacy and Fourth Amendment issues that are likely to arise. And third, I want to conclude by offering some tentative suggestions for how the law is going to need to develop if the Fourth Amendment is able to deal with privacy and technology in the 21st century. So let me begin then by making a fairly bold claim that the recent Supreme Court decisions bode poorly to predicting the ability of the court to deal with technology in the Fourth Amendment. There have been 2 Supreme Court cases about this in just the last few years. I want to tell you about them. One was a couple of years ago. It was a case called City of Ontario versus Quan. It involves the SWAT team of the Ontario Police Department in Ontario, California, not far from Los Angeles, and very close to where Judge Quackenbush regularly sits. And the Ontario Police Department gave to its officers, the SWAT team, text pagers. And each officer was given a message allotment with regard to the use of the text pager. The officers were told, though, that if they went over their allotment, it wouldn't be a problem so long as they paid for overuse. Now, each of the officers had previously signed an agreement that whenever using city-issued electronic equipment, there would be no expectation of privacy. Also, they signed an agreement that they would not send sexually explicit messages. However, remember, the lieutenant said, so long as you pay the overuse, no one's going to read your text messages. Jeffrey Cron was an officer on the SWAT team in the City of Ontario Police Department. he went way over his message allotment each month. For the first several months, he just paid the overuse and nobody bothered him. But then the lieutenant got tired of dealing with this each month and asked the wireless provider, Arch Wireless, to provide a transcript of Quan's on-the-job text messages. He wasn't concerned what Quan was doing with his text pager off the job, but he wanted to see how often the on-the-job text messages really were job-related. Well, it turns out that only a very small percentage of them were job-related. Quan was regularly texting to his wife. He was regularly texting to his mistress, who was a former officer of the department. And he was regularly texting to friends. The lieutenant, seeing that Quan was regularly violating the rule that the text page would be used only for job-related purposes, disciplined Quan. Quan filed a lawsuit. He was joined as co-plaintiffs by his wife and his mistress. I mean, everyone's imagination, the coordination that went on to file that lawsuit. Learned through the press that it's now his ex-wife who joined him. And they claimed a violation of their Fourth Amendment rights. They claimed that this infringed their reasonable expectation of privacy. It was tried to a jury in Riverside, California. Judge Stephen Larson presided. And the judge, based on the jury verdict, ruled against the plaintiffs. The Ninth Circuit, in opinion by Judge Kim Wardlaw, reversed. Judge Wardlaw, writing for the Ninth Circuit, said that Quan and the other plaintiffs had a reasonable expectation of privacy. The lieutenant had specifically said no one would read the text messages so long as the overuse was paid. The Supreme Court granted review. This poses so many important issues. They were all briefed to the Supreme Court. How is the reasonable expectation of privacy determined for purpose of the Fourth Amendment? Is it controlling that Quan signed a statement that he had no expectation of privacy in using city-owned electronic equipment? Or is it determinative that the lieutenant told him no one would read his text messages if he paid the overuse? What's the expectation of privacy of the third parties, the wife and the girlfriend? I know when I send somebody a letter, the recipient might post it on his or her door for all to see. But I know if I'm in a phone conversation, I have a reasonable expectation of privacy. But where does text paging, relatively new technology, fit into that matrix? The Supreme Court decided none of that. They didn't just brief and argue, but the Supreme Court ruled very early. The court was unanimous. Justice Kennedy wrote to the court. And he said, whenever we are dealing with new technologies, we should be cautious about issuing legal rules. Justice Scalia concurred, but he disagreed as to that. He quoted Bob Dylan, "The times are changing." I like Justice Scalia quoting Bob Dylan. And he said, we should face the hard questions that are presented. But instead, the Supreme Court said it wouldn't decide whether there was a reasonable expectation of privacy. The court would just hold that the lieutenant did in reading the text messages was reasonable. The lieutenant had a reasonable interest in knowing that the text messages were job-related, and that decided the case. The court faced none of the hard issues with regard to the Fourth Amendment and new technology. I think the most recent case bodes even more poorly to the likelihood that the court will really deal with new technology in the Fourth Amendment. The case is the United States versus Jones. It was decided a couple of months ago. Police in Washington, D.C. suspected that Antoine Jones was engaged in cocaine trafficking. They went to a judge and they got a warrant. The warrant authorized tapping Jones' phone. The warrant also authorized putting a GPS device on Jones' car and tracking his movements. Now, the judge in issuing the warrant said that the GPS device had to be planted within 10 days of the warrant's issuance, and that the GPS device had to be placed on the car when it was in the jurisdiction of the court within the District of Columbia. The police waited until the 11th day to put the GPS device on the car. Inexplicable why they didn't do so within the terms of the warrant. And also they put the GPS device in the car when it was in Maryland. So there's no dispute whatsoever there was not a valid warrant. For 28 days, the police tracked the movements of Antoine Jones. When ultimately he got prosecuted for cocaine trafficking, the logs from the GPS were key evidence against him. He was convicted, sentenced to life in prison. He was ordered to pay a large fine. On appeal, he argued that putting the GPS device on his car and following him for 28 days was a violation of the Fourth Amendment, since there wasn't a valid warrant. The United States Court of Appeals to the District of Columbia Circuit agreed. Judge Douglas Ginsburg wrote to the court. He said that Jones had a reasonable expectation of privacy, that the government would not follow his movements for 28 days without a warrant. There was a strong dissent from the denial of en banc review. Chief Judge David Santel said, "We have no expectation of privacy. We're on public streets." Judge Santel said, "The police could have had an undercover car follow Jones at all times he was out on the streets. No expectation of privacy then. Why then is GPS tracking any different?" The Supreme Court unanimously affirmed the D.C. Circuit and held that the planting and following of Jones via the GPS device violated the Fourth Amendment. But it wasn't unanimous with regard to the opinion. Justice Scalia wrote for the majority, and he said that under an English law decision from 1765, planting the GPS device on the car should be regarded as a search. Justice Scalia said, "The Fourth Amendment means the same thing today as it did when it was adopted in 1791. And planting the device on the car under the 1765 English precedent would be regarded as a search within the meaning of the Fourth Amendment." I always find it at least anomalous when the court says, "The Fourth Amendment means the same thing today as it did when it was adopted in 1791. Now let's talk about GPS devices on cars." Indeed, Justice Alito wrote an opinion concurring in the judgment, saying just that. His opinion was joined by Justices Ginsburg, Breyer, and Kagan. Justice Alito said, "It makes no sense to decide what's a search within the meaning of the Fourth Amendment when dealing with electronic equipment to look at English law from the 18th century." Justice Alito said, "We should focus on the reasonable expectation of privacy." He said, "We all have a reasonable expectation that the police won't track our movements for 28 days without a warrant." Justice Sotomayor wrote a curious concurring opinion. She said she agrees with Justice Alito more than Justice Scalia, but she joined Justice Scalia's opinion to make it the majority opinion. Had she joined Justice Alito's opinion, his would have been the majority opinion. And she said neither Justice Scalia nor Justice Alito really provides a framework for dealing with all of the hard issues. What if, for example, this wasn't a GPS device on the undercarriage of Jones' car? What if this was a satellite that could just track Jones's movements? Would that be a search within the meaning of the Fourth Amendment? How do we decide when there's a reasonable expectation of privacy? And surely a trespass isn't the key any longer for there to be a Fourth Amendment issue. Katz rejected that in 1967. As I read the opinions in these two cases, Quan and Jones, I come away with the conclusion that the court's not thinking about, not even able to deal with technology in the Fourth Amendment. Well, this brings me to the second thing that I wanted to talk about. I think that the conceptual frameworks that exist are ill-suited to dealing with privacy issues in the 21st century. So lest it seem that I am just criticizing these justices and how they wrote their opinions, what I want to argue is there's a larger, more systemic problem in the law. That the way in which the law has developed concerning privacy is ill-suited to dealing with the issues such as those Justice Sotomayor identified. And I think part of the problem is that the term privacy is used in so many different ways by the Supreme Court and by academics and commentators that inherently it leads to confusion. The first mention of privacy in a Supreme Court opinion doesn't happen until the 20th century. In fact, everyone knows, privacy nowhere appears in the Constitution. The word wasn't used at the Constitutional Convention in Philadelphia in 1787. So far as we know, it wasn't used at the state ratifying conventions. In the discussions of the Fourth Amendment, not very many, prior to its adoption, no one spoke in terms of privacy. Many trace the modern use of the word privacy to an article by Brandeis and Warren in the Harvard Law Review in 1895 titled The Right to Privacy. One reads that article, though, it's not about privacy as I'm talking about today in the Fourth Amendment context. What Brandeis and Warren were concerned about was public disclosure of private facts. They were complaining about a media that was too obsessed with celebrity and too focused on revealing scurrilous details. Now, one could read the introductory and concluding paragraphs of that article and think it was written in 2012, not 1890s. But their focus had nothing to do with the Fourth Amendment, nothing to do with eavesdropping or electronic surveillance. They say the court didn't deal with that until 1928 in Olmsted, and did so poorly at the time. Over the years, the Supreme Court has come to use the term privacy in three very different contexts. One concerns intrusion, especially by the government. Obviously, the Fourth Amendment is limited to state action, and so that's what we mean when we talk about privacy in the Fourth Amendment context. Intrusion by the police, homes, their persons. There's also a tort of intrusion that would apply to private conduct. An example here, again using new technology, is a Supreme Court case of about a decade ago, a case called Kylo versus United States. Kylo involved whether thermal imaging of a home is a search within the meaning of the Fourth Amendment. Police had suspicion that it was a marijuana growing operation in a home, and they went and took a thermal picture of the house. I've actually seen that photograph. It just looks like a house with bright lights on in the attic. So those lights in the thermal picture were showing heat loss, the consumption of energy consistent with the marijuana growing operation. And the Supreme Court had to decide, is a thermal image of a home a search within the meaning of the Fourth Amendment? Is it an intrusion? The Supreme Court, in an opinion by Justice Scalia, said yes. He stressed that homes are especially protected under the Fourth Amendment. He said that the police will now or soon be able to even learn about intimate activities by looking at the thermal images of bodies and what they're doing in the homes. And in this sense, to him, this was an intrusion. There's a second sense in which the word privacy is used by the Supreme Court and others. And this concerns control over information. Not concerned here with the idea that the police are going to come into our home physically, electronically, but instead that there's information that all of us want to hold and keep private. This information might be revealed by the government, might be revealed by others. Again, it's the government doing so. We're then talking about privacy, not in a Fourth Amendment sense, at least under the liberty of the Due Process Clause. If it's private revealing of information, it would be a tort. Concerns over databases, really a concern over control over information. When Warren and Brandeis are speaking of the right to privacy, it's this that they were focusing on, informational privacy. But there's a third way in which the Supreme Court has used privacy, and that's in the sense of personal autonomy. In Griswold versus Connecticut in 1965, the Supreme Court specifically used the phrase, the right to privacy, in discussing how a Connecticut law prohibiting purchase or use of contraceptives violated the Constitution. Justice Douglas wrote that opinion and talked about how privacy, and that was his word, was protected by the penumbra of the Bill of Rights. He said even though privacy isn't mentioned in the Constitution, there are aspects of privacy protected by the First Amendment, the Second Amendment, the Third Amendment, the Fourth Amendment, the Fifth Amendment. One commentator said that Douglas was like a cheerleader skipping through the Bill of Rights and finding, give me a P, give me an R, give me an I. Privacy is the number of the Bill of Rights. I think that Justice Douglas's opinion in Griswold contributed greatly to the confusion with regard to the right to privacy. Now, in part, it's I think that this last notion isn't really privacy, as we think of it, but autonomy. But by using the word privacy instead of autonomy, the court created confusion. Also, if you remember, Justice Douglas in Griswold said that what was objectionable about the Connecticut law is, and I'm going to quote his words, that we wouldn't want police searching the marital bedroom for telltale signs of the use of contraceptives. In other words, he didn't say there should be a right to use contraceptives because there's a right to reproductive autonomy. He talked about concern about police searches of bedrooms, finding information about contraceptives. That's about intrusion in informational privacy. And I think that in this and in other cases, the Supreme Court has created confusion by not separately dealing with intrusion, informational privacy, and autonomy. Now, I also would suggest to you is to each of these three concepts, the Supreme Court has done a poor job of developing a conceptual framework for dealing with issues, especially those of technology in the 21st century. Let me focus first on the intrusion notion. Katz was seen as such tremendous improvement over Olmsted. Reasonable expectation of privacy seems far better in deciding what's a search within the Fourth Amendment than trespass. Once police could gather information without needing a physical trespass, surely there had to be a way to protect us from the police gathering information about us, things that used to require the physical trespass. However, reasonable expectation of privacy seems so inherently flawed as an approach to dealing with intrusion, especially intrusion by technology. At the very least, it has the ability to be self-defeating. Does this then mean that the government can keep us from having any Fourth Amendment rights just by saying, have no expectation of privacy in this context? If the government were to announce to everybody, we have the ability to listen to your cell phones at any time, does that then mean there's no Fourth Amendment protection because we have no reasonable expectation of privacy? In fact, there are a number of cases recently that involve police looking at the contents of laptop computers when individuals cross the border. There's some cases where the police literally will turn on the laptop and look at all of the contents of the laptop and things like child pornography, then prosecute the individual. And the issue is not yet come to the Supreme Court, but is the Fourth Amendment protection for the content of laptops, say at the border? And the Ninth Circuit has ruled, and the Supreme Court has denied a review, that you shouldn't have a reasonable expectation of privacy when you cross the border, because the government tells us we don't have any expectation of privacy when we cross the border. The government has the ability to control the border. If the government can do so then, can the government always take away our Fourth Amendment rights just by telling us, here you don't have any reasonable expectation of privacy? I think the problems with the reasonable expectation of privacy go beyond that. The reasonable expectation of privacy seems to be a descriptive statement. Do people in the particular context expect privacy? I imagine the only way to do that would be to do a survey of people and ask them, in this context, do you have an expectation of privacy? But shouldn't the expectation of privacy be determined normatively, not descriptively? Is it really the underlying issue when people should be protected, not when they actually expect to be protected? I think this is an issue that was identified long ago by Justice Harlan, explaining the confusion that comes with speaking of reasonable expectation of privacy. Now, it seems to focus on expectations rather than normative considerations. The second kind of privacy that I talked about is informational privacy. And I think the Supreme Court has done an even worse job in this area than it has with regard to intrusion. There is no Supreme Court case in history that has ever found that informational privacy is protected by the Constitution. There are two cases where the Supreme Court said it would assume without deciding that informational privacy is protected, but because the court then ruled against the claims of informational privacy, they had no occasion to elaborate upon it. One was a case called Whalen versus Roe. New York had a law that required that doctors and pharmacists provide copies of prescriptions for certain particularly dangerous controlled substances. And then these prescriptions were compiled in a central database in New York. And an objection was brought that this would violate people's right to privacy. That if somehow they could get access to this information, others could learn personal use of drugs, prescription drugs, medical conditions, and the like. The Supreme Court said, as I mentioned, they would assume that there was a right to informational privacy, but it wasn't going to decide the question, and then it upheld the New York law. The court said the state has an important interest in monitoring controlled substances, so this kind of a central database doesn't violate anybody's constitutional rights. The only other Supreme Court case dealing with informational privacy was just last term. There's a case called NASA versus Nelson. It involves the Jet Propulsion Laboratory, or federal government, which is also part of Caltech University in Pasadena, California. It used to be that individuals for most positions there didn't need to go through a background check. However, pursuant to an order by President Bush after September 11, the government now requires that all the employees there undergo a fairly thorough background check. And as part of the background check, they have to list whether or not they've used illegal drugs, whether they've ever undergone counseling for the use of illegal drugs, and the like. And an employee there brought a lawsuit saying that it violates my right to privacy for them to ask for this information. He said, there's nothing about my job at JPL that in any way relates to national security. He said, I don't have access to classified information. I'm not working on projects where I can compromise the United States. To have this kind of background check, learn, for example, what psychological counseling I've undergone, violates my right to privacy. The Supreme Court ruled against Nelson. And this is a similar pattern where the district court initially ruled for the government, the Ninth Circuit reversed, and then the Supreme Court unanimously reversed the Ninth Circuit. Justice Alito wrote the opinion to the court, and he said, as in Whalen versus Roe, we assume that there is a right to informational privacy, but we don't need to decide that because we believe the government's actions are reasonable in requiring background checks. I think it's interesting that Justice Alito used the word reasonable in upholding the government's action. Doesn't that assume that there's not a fundamental right? We usually use in constitutional law the term reasonable when we're discussing rational basis review, the lowest level of review. That's not the language of a fundamental right. So the court said they were assuming some right. In reality, they weren't providing much protection at all. As I say, ruled unanimously for the government. Justice Scalia wrote an opinion concurring in the judgment joined by Justice Thomas, where he said flat out, there is no right to informational privacy under the Constitution. So when you think of protection of information, when you think of all the information that the government has to follow us, there's no protection in the law other than these couple of statements in the Supreme Court. They would assume such a right without deciding it. The third aspect of privacy concerns autonomy. Here there are far more in the way of Supreme Court decisions. But the Supreme Court has been safeguarding aspects of autonomy under the liberty of the Due Process Clause for almost a century. And I can list for you the many rights that have been protected with regard to this aspect of privacy. The Supreme Court has said, for example, that there's a right to marry that's protected under the liberty of the Due Process Clause. There's a right to procreate, a right to custody of one's children, a right to keep the family together, a right for parents to control the upbringing of their children. As I mentioned in Griswold versus Connecticut, the right to purchase and use contraceptives, the right to abortion, the right to engage in private, consensual, adult same-sex sexual activity, the right to refuse medical care. And yet what's missing from all of this is any underlying theory of how is a court to decide what aspects of human behavior are protected as fundamental rights under autonomy in which the government can regulate. I'll give you an example from one of the most recent decisions concerning privacy in the sense of autonomy. It was a decision from 1997. It's a case called Washington versus Luxembourg. It involved a challenge to the state of Washington law that prohibited aiding or abetting suicide. There was a lawsuit brought by terminally ill patients here in Washington, arguing that the right to privacy should include such a liberty. The district court, Judge Barbara Rothstein, found in favor of such a right, relying on the liberties that I just mentioned. The Ninth Circuit initially reversed, and then in a 7-4 en banc decision, the opinion by Judge Stephen Reinhardt found that the right to privacy does include a right to physician-assisted death. The United States Supreme Court unanimously reversed. Chief Justice Rehnquist wrote for the court and said there is not such a right protected under the Constitution. But why shouldn't there be such a right once the Supreme Court says that there's a right to refuse medical treatment? Those on life support could order their doctor to turn it off and thus have a right to physician-assisted death. What about those who work on life support? If the point of cases like those dealing with abortion, right to refuse medical care, or a right of bodily autonomy, a right to make crucial decisions concerning one's life, why doesn't it extend to a right to physician-assisted death? There's no principled distinction there. What's missing with regard to privacy autonomy is any conceptual framework determining what aspects of human behavior are fundamental rights and what not. So it's for this reason that I think that the analytical approaches used by the court with regard to privacy are so ill-suited to the 21st century. Well, this brings me to the third and final part of my remarks. I want to point to directions that need to be taken with regard to privacy. And I think it follows so much from what I've already said. I think that it's essential that the Supreme Court be much clearer in separating the different aspects of privacy. I would prefer that rather than just using the ambiguous word privacy, we develop a much more particularized vocabulary, speaking of privacy in terms of intrusion, privacy in terms of control over information, privacy in terms of autonomy. I think it's then essential in each of these areas to develop a conceptual framework to deal with the enormous number of issues that are going to occur because of new technology in the 21st century. We need to develop a normative approach to determining when people should be able to have an expectation of privacy. I don't think we should talk about reasonable expectations of privacy in terms of what people actually expect. Instead, we need to develop a theory about when do we want people to be able to expect privacy from government intrusion. The cases decided by the Supreme Court don't even begin to point in that direction. We need to develop a conceptual framework for what is that information about a person where the person should be able to believe that it's not going to be revealed or disclosed. For each of us, there are facts, think of them, that we wouldn't want others to know. In fact, I think there's a way of conceptualizing this in terms of concentric circles. There's things that I've never shared with anybody. There's things that only my wife knows about me. There's things my wife and children know. There's things my best friend share. There's things that the world knows. But we need to develop a way of determining what's the constitutional protection for information. In a world of databases, in a world where almost everything about us so can be easily learned by the government, by others, we have to develop a better way of approaching informational privacy. And it's time, I think, for constitutional scholars to develop that underlying theory with regard to autonomy. How to separate the behaviors that the government can regulate versus those that are truly part of autonomy. To me, this really seems the roadmap for dealing with privacy in the 21st century. I began by quoting Justice Brandeis' opinion from Olmsted. The dissent's most famous because of another quote from it. In it he said, that the greatest threat to liberty will come from people acting for beneficial purposes. He said, people born to freedom know to resist the tyranny of despots. He said, the insidious threat to liberty will come from well-meaning people of zeal with little understanding what the Constitution is about. Now, Louis Brandeis couldn't have imagined the technology of the 21st century, but I don't think there'd be better words about the threat we now face to our privacy.
Dean Chemerinsky, are you willing to take a couple of questions? Questions?
I have a question.
Please.
Professor, the quandary that I think about a lot is when my 20-year-old has no compunction giving Google the right to privacy on his computer, his phone, his sister's phone, probably mine. It's just a generational attitude of privacy that is so different from those we had and probably our predecessors.
I was very careful to speak of privacy in the constitutional sense relative to government. There's a whole set of other issues that rise with regard to privacy relative to private entities, and especially privacy with regard to the internet. I've often spoken on that topic, and I've said over and again to audiences, you should have no expectation of privacy at all when you're using the internet. And I'll give an example, one that relates to the administration of a law school. At the end of last week, I said to my director of IT, is there any way to find out who's visiting our website so as to be able to decide how we want to redesign it? And she came to me yesterday with a multi-page printout that disclosed what state each visitor was from, what country each visitor was from, how long they came, where they first went, what page they exited from. It was unbelievable the amount of information that could be gained very quickly. And of course, much more sophisticated, those who are analyzing data, can find so much. I mean, I'll tell one other story about this. And this is a story now from 18 years ago. I received a call from Nightline, remember the Ted Koppel show, saying they want to do a program on how much information can be found from somebody if they really wanted to learn about it. And they said, we're going to hire an information broker to look for information about you. I said, well, I don't know. The way I found out, they said, give us your social security number. And so I said, yeah. And I said, why do you need my social security number? Because they don't pay you to go on a show like that. He said, we want to hire this information broker to learn as much about you. And I said, I don't want to do this without checking with my wife to make sure it was okay. I don't have anything that would really be embarrassing to find out about. So they did this, and they found a tremendous amount of information. Nothing embarrassing about me, but it was astounding what they could learn about me, the size of my house, my political affiliation, things about my family, and all of this. All of this is just out there. Now I can get to your question. There's no doubt that people who've grown up in such a world are much more accustomed to not having privacy than those who are older. To me, that fits with what I was saying is that it can't be then we determine what's the reasonable expectation of privacy based on what people actually expect. It has to be normatively what we want people to have by way of privacy. Because otherwise, it becomes ever less as we just become accustomed to ever less in the way of privacy protections.
Other questions? Yeah.
You talk about, it sounds like you're saying it's like, in order to answer this question, we need to change the language with which is used in order to come up with an underlying principle for which these decisions need to be made. How would this group or how does that begin?
I believe that words really matter. And I think that a great deal of the problem with regard to dealing with privacy is because of a language problem. I think Justice Douglas in Griswold did a tremendous disservice to the law here for the reasons I said by calling autonomy privacy and focusing on the privacy of the marital bedroom rather than letting people decide whether or not to have a child. So I think it's important for scholars to say to the judges and to the court, let's be more precise in our language. And then I think it's important to say, let's for each of the categories begin to develop a conceptual framework that doesn't now exist. I don't have that conceptual framework. And I don't tend to come here to identify one for you. I just want to say that I think there's a really serious problem. And the start, I do think, is having a much better vocabulary to deal with it.
One more question?
Oh, could you choose?
You go ahead.
Okay, then call the judge. Okay, and then the judge again, yes, please.
Yeah, Dean, we're well aware that since 9/11, the government has been surveilling potential terrorists for our own personal safety. And I suppose we should all be grateful for that. But what about when the government starts using these techniques for an ordinary criminal investigation? You mentioned, or Justice Sotomayor mentioned, or concurring opinion that searches can be conducted of everyone anywhere and by satellites or whatever. So does that mean that right now there's no limitations on the government's ability to do that? Or do we need statutory change for implementation?
I'm going to start where you end. All of what I've talked about could be dealt with through better statutory protection. After Katz, Congress passed the Omnibus Crime Control Act in 1968, and Title III provided rules with regard to electronic eavesdropping, wiretapping, modified by the Foreign Intelligence Surveillance Act for a certain category of wiretapping. But certainly, we don't need to turn to the courts for solutions to all of this. However, if we're focusing on the Fourth Amendment, the Fifth and 14th Amendments, that really does then come down to the courts. In terms of where you began, I think that the Fourth Amendment framework can work, but I don't think it's been used nearly enough. What you're alluding to is, say, for example, when police are infiltrating lawful civilian groups or religious groups. I think that what the law should be here in a longer conversation is we should require a warrant based on probable cause to do this. I'm very concerned about police infiltration of civil groups, religious groups, having a chilling effect on speech. I think that there is a genius to the Fourth Amendment. Say, we don't want to just trust police on their own. Let's have the police go to the independent judges and let them decide whether or not there's a basis for an intrusion. Infiltration of civilian groups, religious groups, is often essential for law enforcement gathering. But there's got to be some check on the police, and I would use the warrant approach.
There's some Ninth Circuit cases that discuss the issue of both state and federal laws that trigger the taking of DNA based on the behavior of an individual. And when they become part of the process, the criminal process, and you could create any number of factual scenarios you wish, but there are a number of cases that deal with whether it's appropriate, and they've given up their right to say no to that. If they want bail, prior conviction just by virtue of arrest, rather than waiting until conviction. And I wonder if this triggers some of those privacy issues, or not privacy, but when behavior of individuals has or has not surrendered their right to autonomy, for example, as to their DNA.
It's a terrific question, and it touches on exactly what I'm talking about. If you couldn't hear, it's about issues where people who are arrested have to give a DNA sample just by a swab of their cheek, or is a condition for bail having to give a DNA sample and the like. First, I really do believe that we should have privacy with regard to our DNA. So much can be learned about us by analyzing our DNA, and as technology goes forward, ever more can be learned. So the idea of the government having this and what they can learn about me is very troubling to me. But there's also then an informational privacy concern. Once there's this DNA database, who has access to it? Now, the law here has clearly not kept up with technology. And the law is sometimes done exactly what you say, say something, you don't have to get bail. But if you want bail, a condition is you got to give a DNA sample. Then they want to put together a DNA database to be able to track criminals. This reminds me of the old unconstitutional conditions doctrine, that the government can't condition a benefit on any given right. There's a benefit in getting bail. I think it's an unconstitutional condition to say that somebody can't have it without even giving up a DNA sample. But when you identify as a huge issue, and if any example is a good one to end what I'm saying, look at how we don't have the conceptual framework to deal with what the judge is identifying, either in terms of intrusion or informational privacy or autonomy. We just don't have the framework to deal with this issue. And that's why courts are struggling with it. And I don't think the Supreme Court's going to do better when that gets to them.
Thank you. And now we're going to hear from Judge Quackenbush, after whom this lecture is named.
I'm going to take the prerogative of introducing Judge Quackenbush.
Oh, okay. Thank you.
Few prerogatives as a federal judge. One of the benefits is being privy to interesting lectures like this one by Dean Chemerinsky. Another prerogative is having fascinating, intelligent, and very good mentors to work with as colleagues. Certainly Judge Quackenbush is the epitome of a good mentor, and as Dean Chemerinsky pointed out, a jurist with a very good national reputation. One of the reasons for our holding this lecture series is to make sure that Judge Quackenbush is recognized in this district as well as he is recognized outside of this district. We would not want to let this prophet go unknown in this land. He is currently working on his 33rd year on the bench. And as such, he has presided in the Eastern District of Washington longer than any other district court judge. His connection with Gonzaga goes back a long ways. He is, in fact, a Gonzaga grad. He was appointed to the federal bench in 1980. He served as chief judge for a number of years, and he achieved senior status in 1995. But that has not deterred him from carrying a very heavy load of cases, not only here in Eastern Washington, but in those districts which have not been fortunate to have new judges appointed, especially Central District of California, Southern District of California, and Arizona, where there are judicial crises. I believe next week are 65 sentencings in Arizona. His personality, his brilliance as a jurist, and his good common sense has made him a leader in our district, somebody who I personally admire a great deal. And today, for instance, at trial, an attorney tried to convince me to give the Judge Quackenbush reasonable doubt instruction. Judge Quackenbush.
Thank you, Rosanna. I won't ask you for the rest of the story, whether or not it was given. Dean, you've honored us, our court, and Gonzaga, and myself personally by being here today and your presentation. This is by far the largest turnout in the 3 years of these lectures, and I think that speaks for itself. I'm sure next year, whoever the speaker may be, will have an equally large turnout because there will be talk and continued discussion of your presentation here today. So thank you very much. Now about the Gonzaga connection. There are now 2 living federal district judges with degrees from Gonzaga. Until recently, there was only 1. Now, with Judge Rice on board, we have 2, but we also have other judges who have Gonzaga connections. Judge Imbronio, Magistrate Judge Imbronio, my first law clerk, is a Gonzaga graduate. Her compatriot, Judge Hutton, who sits in Yakima, is a Gonzaga graduate. And Judge Patricia Williams, our bankruptcy judge, is also a Gonzaga Law School graduate. So there is the connection. This all started, really, in the late 20s or early 1930s, when my father, then the football coach at Hilliard High School, the predecessor of John Rogers High School, started law school at night with a fellow Hilliardite who was working in the service station at Hilliard. His name was Ralph Foley. They, of course, both successfully graduated, both became Superior Court judges. When I, having been called back into the Korean War, finished that service, came to Gonzaga to finish my legal education, I had the opportunity to spend 2 years as Judge Ralph Foley's courtroom deputy. Invaluable training. And with Father Coughlin's assistance, we of course on the campus have the Ralph Foley and Helen Foley building. He also had a son, Thomas Foley, who became a deputy prosecutor with myself, Leo Driscoll, Dick McWilliams, others. And I had the opportunity of being Tom Foley's first campaign manager. And of course, we now have the Thomas S. Foley United States Courthouse. So there is the connection between the court and Gonzaga University. And I'd like to acknowledge Father Coughlin, retired president of Gonzaga, my good friend, and my good friend on the left, Father Costello. We have regular meetings, my good friends, along with Mr. Workland. Is he here? Or is he sitting in the Workland conference room next to the dean's office? Oh, yes, Mr. Workland, on my right. The opportunity to join with Father Godwin and Father Costello is something that's very dear to me, and I thank you both for being here today. I want to thank Judge Shea, who really started this lecture series. I did protest to some extent, saying I wasn't that old yet, but Judge Shea convinced me that I was. And he then started these lectures, and once again, Dean Chemerinsky, we thank you very much for taking your valuable time. Federal judges throughout the country have benefited for years from the presentations such as this that the Dean has made, going back to my first days of Ninth Circuit meetings when we were much smaller. The Dean was younger, as we all were, and he just has been an invaluable asset to the federal judiciary as a whole. And so I thank you very much. And I thank you all for your attendance.
That concludes the program today. Please join me again in thanking Dean Chemerinsky and the federal judges for making this wonderful event possible.